In a civil lawsuit in New York, if the defense wants to have you examined by a doctor of their choosing and you refuse to do so, what can happen to you and your case? Would you like to know the answer? Come join me for a walk around the neighborhood as I share with you exactly what can happen. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Okay, so you brought a lawsuit seeking money as a form of compensation for all of the harms and losses and damages you incurred because of someone else's carelessness. Maybe it was a careless driver. Maybe you tripped and fell in front of somebody's property that was defective. Maybe it was a careless doctor. Now, the defense turns around and says, hey, we don't really know if the treatment that you received is accurate. We don't know exactly what your medical condition is right now. And we don't have the ability to understand your full medical condition just by looking at you when we question you during the course of your lawsuit in a pretrial process known as a deposition. So the defense turns around and says, hey, we would like you examined by a doctor of our choosing. We are going to designate a neurologist and also an orthopedist in this scenario to examine you. Now, my question to you is, do you have to go? What happens if you don't go? So let me answer those questions. In this type of lawsuit, the defense is permitted, they are permitted, if they choose to do so, to designate a doctor whom they believe is appropriate to examine you, to evaluate your current medical condition, to evaluate any problems you have, and then write a report and analyze exactly what issues you have today and whether they are connected to the treatment or the improper care or to the injuries that you suffered by their client. So they are permitted to do that. So let's now say that they do exercise that right. And they say, you know what? We're not sure that all of your medical records are accurate. We don't know. You haven't been to a doctor in a while. We want to see exactly what your problem is now. We want to see if you have any functional deficits. Are you unable to do certain activities now? And we want to be able to confirm that by having a qualified medical expert examine you. Okay, so now they notify us that they are designating 2 different doctors to have you examined. And now we are in the process of trying to schedule those appointments for you. During our attempts to schedule those appointments, you turn around frustrated and say, I can't believe that they don't believe that I have these injuries. This is ridiculous. All of my doctors, they have those records. Why don't they believe me? I'm not going to any of their appointments. This is nonsense. Now, if you choose that route, if you choose not to go ahead and to comply with going to a physical examination by a doctor of the defense attorney's choosing, you run the great risk that now the defense will turn to the court and say, Judge, Mr. Oginski's client is preventing us from seeing what type of medical issues and medical problems this client has currently. We don't know what problems this person has other than what they told us about, but we need to verify for ourselves with our own medical experts the full extent of this client's injury. And if this person refuses to appear for this designated physical examination, we are now at a significant disadvantage. And if you force us to go to trial, now we won't be able to evaluate properly, and certainly for negotiation purposes, we will not be able to properly evaluate whether or not this person's injuries truly are limiting, truly are disabling. If they really are disabling and permanent, then maybe it's time we go back to our carrier so that now we can go ahead and begin settlement negotiations. But if not, if it turns out that this physical examination reveals that this person is exaggerating or they don't have any problems now, then we are fully justified to go to trial and show to a jury that this person doesn't have the injuries that he claims he has, or that his injuries are not as significant as he claims them to be. So the judge looks at this, and then they will turn to me, and the judge will say, Mr. Oginski, why isn't your client appearing for a physical examination, in which the defense clearly has a legal right to do? Judge, my client is morally upset and morally angry that he now has to go for a physical examination. And you know what the judge will say to that? Tough noogies, really. That's basically what the judge will say. Listen, your client chose to bring a lawsuit, which means that his medical condition is put into issue, which now gives the defense the opportunity to go ahead and designate a doctor to examine your client. And yes, that is true. If your client refuses to appear for these designated physical examinations, guess what? I'm going to have no choice but to prevent your client from testifying at trial about any of his injuries currently and any of his problems that he's going to have into the future, which means that any of his treating doctors now that you bring in to testify in his behalf will be precluded from discussing any of their opinions or conclusions about what problems he has today, as well as what problems he's going to have into the future. And then the judge says something off the record and says, listen, it would benefit your client to go ahead and go for these physical examinations, even though we know what these defense examinations really are. They're basically an attempt to try and minimize and limit the type of damages that you have. That's their goal, that's their function. And there's nothing independent about these examinations. So don't think for a second that when the defense says, hey, we want a doctor of our choosing to examine you. Number one, this is not a doctor whom you are going to establish a doctor-patient relationship with and go to him or her for advice, for medical advice, or for treatment. Instead, their goal is to examine you and then to try and do everything possible to minimize the extent of your current problems or disabilities or limitations. So now your attorney comes back to you and says, listen, if you don't go forward with this physical examination, the judge is going to do something drastic and it's going to hurt you tremendously if we wind up going to trial. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand. And does this happen from time to time? Yes, a client will be very upset that they now have to go through another process of another doctor being examined to see what problems and injuries you have. Yes, it's inconvenient. Yes, it's not pleasant. However, in this type of scenario, in this type of lawsuit, it is necessary to give the defense the opportunity to understand truly what problems you have. You know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.